Hi, it's Mike DelSignore, Saturday morning here, and I want to talk about a letter that many people have been getting. If you took a breath test from the years 2011 to 2019, you may have received a letter in the mail indicating that you can vacate your plea and have a new trial. And I want to explain what that letter means and tell you what you should do and give you some advice on how you should handle that letter and why you got that letter. So back in 2011, myself and a lot of other attorneys, we filed motions challenging the scientific reliability of the breath test machine. This litigation was called the Ananias litigation. It started out about the source code, about when your breath test reveals a result, how does the machine, the computer program, work? Long of the short is there was a lot of legal issues, but the hearing morphed into an issue about did the Office of Alcohol Testing have a reliable method to annually certify the machine? So all scientific agencies are supposed to have procedures and policies and methods for certification, and the Office of Alcohol Testing didn't. So Judge Brennan, who was in charge of hearing all these cases that were combined, if you're one of my clients, you went through this litigation and almost all of you had your breath test excluded, and many of those cases were not guilty verdicts. But if you resolve the case, either I was your lawyer or another attorney was your lawyer from 2011 to 2019, you can bring the case back to court. So what happened was Judge Brennan initially excluded all breath tests prior to September 14th, 2014. Because it was after that date he found that the method to certify the machine was reliable enough that the test could come in. So we had initially 2 years of breath tests knocked out. Later, there was other litigation on the breath test from 2015, 16, and other breath tests, and it was revealed that the government had not provided all the documents in response to discovery. So he extended that order. And that order went all the way to basically August of 2019. And that was for a discovery violation. And the way that came about was Tom Workman, who was an expert for the defense, discovered that when he was doing his public records request, he was getting more documents than we were getting in the litigation. So he really pieced this together and was the brains behind it. When the breath test litigation started back in 2014, myself and about 5 other lawyers, we were at Tom's office and going over these documents that lawyers had never seen before. The government had never provided these documents, and it was discovered that there was all these documents that the Office of Alcohol Testing kept and never provided. And the one thing that came about was there was some documents, and it looked like there was documents attached. There was a paperclip copied, and the copies were never discovered. And what was found is that there was missing tests where the machine hadn't calibrated. So that was the reason why breath tests haven't been used from August 2019 to 2011. The government wasn't admitting these tests into evidence. But if you pled before that, we may be able to move for a motion for new trial and have your case heard again. Now, the case could get dismissed. I had one where I filed it maybe 6 months ago. This issue isn't really new in the sense that you couldn't have done this before, but the letter is alerting thousands of people about this issue that hadn't understood that they could reopen their OUI case. So that's the key thing about this letter is it's really raising public awareness, because even clients that I had and other attorneys, we were expecting an onrush of people bringing their cases back, and I think a lot of people either put it out of their mind or didn't quite grasp the significance of this. So let's say, for example, you're on a suspension for a third OUI, but one of your OUIs was a 2013 with a breath test. If you vacate that suspension, your refusal suspension would change, and your potential penalties would go down from a third offense to a second offense. Even if you resolve the case again, you're still better off. So, and in many cases, the government's not going to be able to prove these cases. So make sure you call an attorney. You can call me. I'll be glad to explain this process to you so you know what to do next. Basically, step one would be filing a motion for new trial, and I think this motion will be allowed. Step 2, the case will go back to court, and we'll have to see if the government can prove the case. Now, if the officer is still around, if it's from 2018, the officer's report, maybe they can prove the case just based on the observations. Also, you may have taken a plea. There was a time period where some judges were advising people that the breath test was not being used and that the plea was based on solely the observation. So it could be that this issue was considered in your tender of plea, that you were advised that the breath test wasn't being used, and then you wouldn't have a motion to vacate because you were only pleading on the so-called observation part of the case. So in OUI case, there's two theories they can prosecute you on: the breath test being over 0.08 and that the officer thought you were impaired based on the observations, the driving, the field sobriety tests. So this issue pertains to what they call the per se theory, the breath test. So contact me. You can call, text anytime, 781-686-5924. I'll go over the letter, go over your case, explain what is the best thing for you to do in your particular circumstances. And I suggest you call, look into this, because it could potentially vacate an OUI conviction. And if you're a multiple offender, could put you back on the road or reduce your suspension.